when Judge Berg was asked to describe the perpetrator who shot him, that person did not have a mask on. Isn't that true?
That's correct.
Okay. And of course, no one in the lineup in which Kevin Smith was asked to be in a lineup had a mask on. Isn't that true?
No, sir.
No
wait,
one,
I'm sorry. Did you ask if the gentleman had masks on
yeah,
during the
no
lineup?
one had a mask on. Isn't that true?
No, that would be silly.
No, I know it'd be silly, but no one had a mask on in the lineup, did they?
No, they did not.
Okay, thank you. Do you know anything about the cousin of Robert Williams being Timothy Russell, or rather Don Diego Adams, being related?
Do I know they're cousins? That's what I was told, yes.
Okay, and you were told by each of them, isn't that correct? And they confirmed it?
That's correct.
Okay. Did you ever hear of a cousin named Harry that had to do with one or the other of either Robert or Don Diego?
Not until today, sir.
Okay. Do you think it was you were trying to be kept in the dark, or that was trying to be kept a secret in terms of the identity that they were in fact related by blood?
Could you ask that
Yes.
again,
Did
please?
you think it was being kept from you, or
What was kept from her?
that they were cousins?
Kept from who?
You.
Or, I mean, by who, sir?
By either one of them.
I never asked them who their other cousins were, so I don't
Okay.
feel that they were withholding family members. I didn't ask, so I don't feel anything was being withheld.
Have you had experience where some family members are covering from other family members in terms of participating or not participating in criminal events?
Yeah.
Okay. Did Robert ever tell you that Kevin had traded a .45 for a gray 9mm Ruger after any shooting?
My recollection is that Mr. Williams told me that the defendant Smith traded a .45 weapon after the shooting. Yes, I don't recall for what type of gun, though.
I see. Did Robert tell you about he and Timothy having robbed an 80-year-old lady on Washburn?
Well, Coach, please.
I understand the court calling me to the bench with regard to that question, and
I don't think that question's relevant for purposes of this particular case and the charges that have been brought. Mr. McWilliams, I'm going to have you move along. Okay?
very well, I
Thank
will.
you.
Agreed. Were you with, at any time, Mr. Robert Williams when it was talked about when and where Kevin Smith was dropped off at or went allegedly after the shooting of Judge Berg?
Yes.
And what is your understanding?
That they were dropped off at Alan Corbin's house on Puritan.
And did you later hear, and was it later stated something by that person to the contrary?
By what person?
Well, for example, Robert Williams.
Did he tell a different story other than that?
Yes.
Not that I recall.
Okay, and how about Don Diego Adams? Did he ever tell a different story?
Not that I recall.
Okay, well, thank you very much.
Anything else, Mr. Rhodes?
Just one question. Do you know, Officer Dillon, around that time period in March of 2015, if the defendant were on again, off again, staying with Alan Corbin at Highland Park?
Yes, I was told that he went to stay there after the shooting.
That's not my question. My question was, do you recall whether during that time period of March 2015, whether the defendant was sometimes living with Alan Corbin on that address? Is it Puritan?
Yes, Puritan.
In Highland Park?
Yes.
Do you recall that?
Yes.
Was that true?
Yes.
Okay. That's all I have. Thank you.
That's right. That's right.
Anything else, Mr. McWilliams?
No, Your Honor, thank you.
Anything by the jury? Thank you, Officer Dillon.
At this time we have marked People's Proposed Exhibit 489, which is a stipulation signed by myself and John McWilliams, which indicates that for the purposes of the felon in possession of a firearm charge, both parties stipulate that the defendant, Kevin Smith, has previously been convicted of a specified felony. Further, between January 2015 and May 2015, the defendant did not have the right to possess a firearm because the requirements for regaining eligibility have not been met. Is that a correct stipulation, counsel?
It is.
I would move to admit 489, Your Honor.
All right, it'll be received.
Now, at this time, the people would seek to waive the balance of the endorsed witnesses as being cumulative to the ones who've already testified.
All right. And with that, the people rest.
With that, the people rest with the provision that any exhibits that have not been received that might be relevant down the road, we would move to admit those subsequent to that. But with that, the people will stay in the chair.
All right, people rest. Mr. McWilliams, how would you like to proceed?
Your Honor, at this time I do have a matter of law I'd like to discuss with the court.
All right, ladies and gentlemen, if you would step into the jury room. Over.
All rise.
Thank you.
You may be seated.
All right, we're outside the presence of the jury. Mr. McWilliams, go ahead, please.
Yes, thank you very much, Your Honor. As the court well knows, the usual practice and proper practice after the people have rested in a felony trial such as this, that the proper thing to do is to ask the court to consider, and we do offer and make a motion for a directed verdict in this matter as to all counts. And I'd like to specifically address one in particular to begin with. May I?
Yes, please.
Okay. You are well aware that the defendant, Mr. Smith, is charged with the charge of assault with intent to commit murder. My argument to the court is that the elements and facts of the testimony of, for example, Judge Berg himself do not, in my estimation, and I argue to the court, do not represent, in fact, a satisfactory showing and proof to allow that issue to go to the jury, because I don't believe that it is established, in fact, the charge of what we normally call AWIM, which is assault with intent to commit murder. I will agree that there is a charge often called assault with intent to do great bodily harm less than murder, and I would say that Judge Berg acknowledged the fact that although a firearm was used, and a firearm certainly is a dangerous weapon and has the capability of causing death and might otherwise be cause for a AWIM charge, but in fact, the proofs are, and I think they came directly from the testimony of Judge Berg, is that although there was every opportunity for the person who was on his porch, had every opportunity to shoot him in the face, shoot him in the chest, shoot him in some other area of the body that would in fact more likely have been fatal, that the person, once the person with the gun, once he was denied access, okay, appeared to have the intent only to punish or to show displeasure, not with intent to kill the person by using and shooting that gun. And in fact, the result is, not to minimize the fact that Judge Berg was a genuine victim in this matter, and I'm sure it was very painful. I'm sure the consequences of going to the hospital and rehab and operations and the agony of the situation certainly was not good, and he was and is a genuine victim. However, I argued specifically to the court that the facts do not rise to the level of assault with intent to commit murder, but only arise to the charge of assault with intent to do great bodily harm less than murder. And I think that's a very important factor, at least on the part of the defense, which gives us some measure either of leverage or some, at least a good point to at least bring to the attention of the court. And of course, in general, the court has the obligation of reviewing the evidence in the most favorable light of the prosecution in analyzing and viewing the balance of the charges before the court with regard to Mr. Smith. Thank you.
Briefly, Your Honor, the court knows the standard much better than I do. People versus Hampton establishes that on a review of a motion for directed verdict, whether a reasonable jury could find the elements exist beyond a reasonable doubt. And the elements of assault with intent to murder require the intent to murder and an assault. In this instance, we have evidence testified by the victim in this case, Terrence Berg, that on March 5th of 2015, that he was approached by the defendant, who's been identified by the co-defendants, asked to go into the house. He was refused. The defendant produced from under his coat a large semi-automatic handgun, pointed at Judge Berg from a distance of about 2 or 3 feet away, and fired that gun. And at the time the gun was fired, it struck the body of Judge Berg and causing a significant injury, albeit to his leg, whereupon the judge fell down, was crying in agony, and the defendants ran away. So the question is, can the fact that someone from 2 to 3 feet away points a .45 caliber handgun at another human being and pull the trigger, striking that individual, causing severe injury, can that rise to the level where a reasonable jury could find beyond a reasonable doubt an assault with intent to commit murder? I would submit that's a question of fact for the jury to decide in this case, because we have evidence that this defendant pointed a loaded handgun at another human being and pulled the trigger from point blank range and struck that individual. And I'm going to argue to the jury that that is an intent to murder someone. And I think the jury ought to be able to decide that.
Anything else, Mr. McWilliams?
No, Your Honor.
On a motion for directed verdict, the court is obliged under People v. Hampton to look at the evidence in the light most favorable to the prosecution and draw any reasonable inferences in favor of the prosecution. Let me address the assault with intent to murder charge specifically. As was stated, the testimony in this particular matter indicated that Judge Berg was on his porch when he tried to resist the defendant entering into his home. And the defendant did in fact have a gun, and specifically this was a .45 caliber weapon. It was a high caliber, powerful pistol. And Judge Berg was shot, as the testimony indicated, from about 2 to 3 feet away. It was the kind of circumstance where while there has been testimony from Judge Berg as well as from his wife of the resulting permanent damage that he has had, there is no getting around the fact that it was fortuitous that a good neighbor came across and assisted rendering some medical assistance, and that he was whisked to the hospital quickly and then had surgery relatively quickly. I do think it poses a question of fact for the decider of fact on whether or not there was an intent to kill. There is evidence, I think clearly, that firing a firearm, a high caliber firearm, from 2 to 3 feet away at a human being and striking that human being, and striking him in a portion of his body where there are major arteries, which could certainly cause death and certainly could manifest an intent to kill that victim, particularly when shooting from such a close distance. I do think that the people have presented enough evidence under the Hampton standard to go to the jury. It is a question of fact for the trier of fact to determine whether or not there was an intent to kill. So the motion for directed verdict to reduce the charge to assault with intent to do great bodily harm is denied. That'll be for the jury to determine. With regards to the other evidence, applying the Hampton standard, there is clearly ample evidence from the testimony of Don Diego Adams as well as Mr. Robert Williams, together with the other circumstantial evidence, to substantiate a conspiracy to commit armed robbery, and the stipulations with regards to the felon in possession are certainly sufficient, and the other evidence that has been presented in this case amply supports going to the jury on the charge of felony firearm. So the motion for directed verdict on all counts is denied.
Thank you very much for that analysis. I do have another thing that we should bring to the
What's that, please?
court, and that has to do with making the court knowledgeable. I'm sure it's already on the record, especially due to the fact that we've had 2 persons who were represented by counsel who were on the defendant's witness list have in fact decided to take the Fifth Amendment, and they will not be called and they will not be testifying. Also on the defendant's witness list was a gentleman who has been known as Mr. Terry, also referred to during the trial as Mr. Man, or some such nickname as that. And I advise the court that although he has been contacted, he not only by my investigator that the court has appointed, he apparently has either refused to be present today or has made himself sufficiently unavailable until sometime in the near future, but certainly not today, and I don't think it would be likely in early next week that he will not be present. Our final witness, outside of the possibility that Mr. Kevin Smith might himself testify, is the girlfriend of Mr. Kevin Smith, and her name is Miss Jones. My investigator has been constantly talking to her. I've talked to her several times in the last several days. She has assured me that she was going to be here today, and assured me that at this point in time, as we draw nearer to the fact that I would go into the hallway and expect her to be personally at that door as I instructed her to do, starting early this morning, that I've had the defendant's mother out in the hallway looking for her. I've been personally out in the hallway looking for her. I know that the officers, some involved in the case, know her personal identity. They've reported to me that they haven't seen her. I haven't seen her. And although I think she is a very important witness on behalf of Mr. Kevin Smith, she has failed or not shown. I'll admit to the court she was not subpoenaed. However, Mr. Smith has generally assured me that she was of such a nature and related to him in such a way that she would voluntarily show up when the time came, and I hate to report to the court and of course confirm with Mr. Smith that she is not here and we will have to proceed without her.
That's right, we will go forward
Yes.
at this particular point. Yes, Mrs.
She's never been down here before throughout this whole case. And her very first time she came down here, they kicked her out for whatever reason, I don't know. She never even been up here before. But they kicked her out, so she wasn't even sure if she was even, she didn't want to drive all the way down here. I had an argument with her over the phone, and she was unsure if she was going to be able to come in here.
Well, let me say this, now that you bring it up, Mr. Smith, I do remember why she was put out, by making the kinds of juvenile type of comments, unacceptable comments.
She's never been here, Your Honor. Y'all got her mixed up with my sister. But my girlfriend never been here. Her first time.
Well, there were two young women who were put out, then I don't understand why she would...
No, when she came by herself, which was, I think it was yesterday or 2 days ago, she came by herself, and they put her out.
Well, if she was put out, it was because all witnesses are sequestered.
First of all, Judge, I'd like to just state what I believe the truth is. I know that she was here because it was confirmed that she was here.
Okay.
And she did say that she thought she had been put out. But I told her she was not put out as a witness at that time, and since she is on our witness list, just because she was put out for some reason does not mean that we weren't going to call her and she couldn't come into this courtroom and testify. That had nothing to do with being put out. I specifically instructed her that she was eligible to be here, she was on our witness list, she was necessary and needed to help Mr. Smith out.
Okay. Well, I would say this, you can look out in the hallway right now. If she's not here, we need to proceed.
Thank you. I'll be
Okay.
right back.
Did you come out with me real quick? With understanding, Your Honor, about...
Wait till you learn.
Your Honor, I report to the court that I went out into the hallway with my client's mother, who would, of course, know who she is, and she reported to me that she did not see her.
All right, well, I think we need to go forward, and we can, we'll see how far we get this afternoon, and
Okay.
if she ends up...
I would also let you know that at this time, we're ready to proceed with the defense of the case.
All right.
And the defense of the case, of course, will give us the option of calling Mr. Kevin Smith himself to testify on his own behalf, as he may and does have a constitutional right to do. And I think at this time it would be appropriate to ask him whether or not he has thought about whether he knows that he has that decision to make, and ask him for his decision, because I think we will go right into his testimony on the defense of the case if he decides to proceed.
Okay. Before we get to that, Mr. Smith, you had a question or something you wanted to...
Oh, it was just something on, like, hearsay or whatever. We could just proceed.
Okay. All right. And I think there were some questions that I know that Mr. Smith wanted to ask. If the parties have it, I'll rule on those questions as they come up. Both sides know what the scope of the question is. I do want to indicate this. In looking at a number of the questions that have been written, I'm looking, for example, at question number 7 that Mr. Smith had written, and that had to do with some incident on Washburn. That's outside the scope of any charge in this particular case. So any reference to incidents that are not contained in the charge of conspiracy or the assault with intent to murder, felony possession, felony firearm are not going to be able to be asked. And we can sort of move along from there. Problem with that?
No.
Okay.
No.
All right.
Your Honor, may we have the defendant arise and...
Oh, yeah, we'll have the jury come out and
What-
then
what
we'll
are the-
vote.
I was alluding to the fact that to give him notice on the record of his
Oh, sure.
rights to
Okay.
either not testify or in fact make a decision to
Okay,
testify.
that's fine, that's fine.
Would you stand up, please, Mr. Smith?
Mr. Smith, I want you to understand that under the laws of the state of Michigan, you have the absolute right to testify, to tell your side of the story with regards to these particular charges. I want you to understand that you also have the right not to testify. If you choose not to testify, then I will instruct the jury that they can't draw any conclusion against you by the fact that you didn't testify. It can't play any part or any role whatsoever in their decision making. But I also want you to know that the decision to either testify or not testify is a decision that you have to make. You may have talked with your family, talked with Mr. McWilliams. They can give you their idea, their opinion, but in the final analysis, the decision to either testify or not testify is a decision that you have to make. Knowing that you can either choose to testify or not testify, what do you wish to do? I'm sorry?
Testify.
Okay, all right.
Your Honor, pursuant to that, I would inform the court that I believe under Michigan Rule of Evidence 609, the defendant would then be subject to questions about his prior convictions. There are home invasion convictions that are separate from these convictions, and they're relevant for the purpose of impeachment, but also relevant because there's been testimony about the nature of the conspiracy and about how the defendant is the one who came up with the conspiracy because he was tired of breaking into people's houses. And that was testified to by Mr. Adams and also by Mr. Williams, and the people would then be asking the defendant questions on cross-examination about his prior convictions for home invasion, not only as impeachment but also as a basis to corroborate the testimony of Mr. Williams and Mr. Adams about the nature of the conspiracy and why the agreement was reached to do these walk-in type robberies.
And in fact, if that was the case, I'm sure that we would have a limiting instruction as to any such testimony or questions, Judge.
All right, under 609, the court has to make a determination as to, first of all, whether the crime contains an element of theft. Certainly home invasion is such an offense. It has to be punishable by imprisonment in excess of 1 year, and certainly home invasion carries either a 15 or a 20-year maximum penalty. And under 609A to D, the court has to determine that the evidence has significant probative value on the issue of credibility. And if the witness is the defendant in a criminal trial, the court further determines that the probative value of the evidence outweighs its prejudicial effect. In this particular case, the court will be giving specific instructions on the accomplice instruction, where the court will be instructing the jury that they have to approach and evaluate accomplice testimony with caution, and that there is certainly a heightened attention given to accomplice testimony in determining the credibility of an accomplice. In light of that, and in light of particularly the fact that there was testimony from, I believe it was Mr. Williams, that there was this decision to do these, quote, walk-in robberies because the home invaders weren't as fruitful. That certainly is something that impacts the credibility, I think, of Mr. Smith. But also, I do think that in terms of weighing the believability of whether Mr. Williams or Mr. Adams should be believed in terms of these alleged activities, or whether Mr. Smith should be believed. I think that the defendant's convictions are in fact probative and more probative than prejudicial, and I will allow it. And I will also give the jury instruction on how those are to be used. Okay?
Thank you very much. And Your Honor, once again, because now you've made that ruling, and now Mr. Smith has heard that, I would just like to confirm whether or not he may have changed his mind about testifying or not, and if that had made any difference. Did it make any difference, Mr. Smith? He said, indicating that that did not make any difference.
All right, that's fine. Bring out the jury. Come on, take a seat.
You may be seated.
All right, the people have rested. Mr. McWilliams, how would you like to proceed, sir?
Your Honor, at this time, we will proceed with the defense of this case and call to the witness stand the defendant himself, Mr. Kevin Smith.
All right, Mr. Smith, if you would stand, raise your right hand for me, if you would, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I know.
Please have a seat.
And of course, at this time, Your Honor, although I did have an opportunity to consider the issue with regard to my opening statement, I think we're ready to proceed and go forward as we're going to do right now.
Okay, that's fine. Thank you.
Sir, would you state your full name for the record?
Kevin Smith.
Mr. Smith, move the mic a little closer to you so that all the jurors can hear you.
Kevin Smith.
Do you have a middle name, Mr. Smith?
Andre.
Do you have, or have you ever gone legally by any other assumed name or different name?
Kev.
Kev, is that correct?
Yes, sir.
That's a street name or friendship name?
A nickname.
Nickname?
Short for Kevin.
Okay, thank you. And how old would you be today?
23.
Okay, and during January of 2015, what city were you residing in?
Detroit.
And over the years, had you gone to school and accumulated friends and acquaintances?
Yes, so I went to Highland Park, and I had two friends, Timothy Russell and Robert
Okay.
Williams.
And those were friends going back to what age were you?
14.
Okay. And you associated with them?
Yes, sir.
And you did things with them?
No, as far as
friendships go and things.
partying, drinking, and all of that stuff.
The answer is yes?
Yes, sir.
Okay. And there was a point in time in which you may have done some things out in Oakland County which you may have regretted?
Yes, sir.
Okay. And how old were you when you did that?
18.
Okay. And as a result of... And who were you with regard to that?
I was with an unrelated person that's not on this case with
Okay. But you yourself had a problem with some misbehavior out in Oakland County?
Yes, sir.
And that resulted in you being out of the community for a while. Is that correct?
Yes, sir.
Okay. And that means you were with the Michigan Department of Corrections, correct?
Yes, sir.
And a point in time you came out.
Yes, sir.
And was one of the things that you were required to do was become employed?
Yes, sir.
And did you?
Yes, sir.
And how'd that go?
I was working at Lawrence Tech and Southfield was a college, but I was doing a dish tank area. Then they let me go because I didn't have the transportation to keep going back every day.
And approximately what date was that that you departed Lawrence Tech in employment there?
Sometime in April. I don't remember the exact date.
Of 2015?
Yes, sir.
Okay. And you exited from the otherwise confinement with the Michigan Department of Corrections in approximately what date?
December 23rd, 2014.
Okay, so you were in the community in January 2015, correct?
Yes, sir.
And you were then back in the community. Were you associating with old friends and reacquainting with people?
Yes, sir.
Okay. Now I want to ask you, you've been sitting here patiently and quietly during this trial, have you not?
Yes, sir.
And you've seen persons come and go and testifying in this matter, have you not?
Yes, sir.
And several of them have been your friends over the years, namely, for example, Robert Williams, correct?
Yes, sir.
And Mr. Timothy Russell, is that correct?
Yes, sir.
Did you ever know a person by the name of Don Diego Adams prior to or January of 2015?
Prior, I knew of him, yeah. I seen him, but I knew of him, but I ain't really like started.
Was that because of your age difference?
No, that was Robert Williams' cousin, so I ain't never like, that's his people. So.
Okay. And how old are you today once again?
23.
Okay. And so you were 22 when you came back in December or January of 2015, is that correct?
Yes, sir.
Okay. And you've heard testimony that certain individuals, allegedly including yourself, came together and had some discussions about some other activities. Have you heard that testimony?
Yes, sir.
Okay. And what if any, for example, truthfulness is and to that those type of discussions?
I didn't plan and agree to rob no old people. None of this stuff in these streets with them.
Okay, well, you know you're charged with what's called conspiracy. Do you know that?
Yes, sir.
And you're familiar because we've talked on a number of occasions about what the definition of a conspiracy is, don't you?
Yes, sir.
And you know a conspiracy essentially is a contract or an agreement, correct?
Yes, sir.
And you know that agreements have acceptance and rejection and parts to it and things like that. Do you know what I'm talking about?
Yes, sir.
Okay. And of course, when we talk about conspiracy, that means an agreement to do something that was wrongful. Do you understand that?
Yes, sir.
Was there conversations between the persons I've just mentioned and you with regard to anything like that?
No, sir. Not
that you participated in?
No, sir. Well, honestly, just being truthful, I did participate in a jewelry store robbery.
Okay. All right. Would that be the jewelry store robbery out in Roseville in May of 2015?
Yes.
All right. And you're saying that was you in the picture?
Yes.
Okay. Well, was that a result of you being in conspiracy or participation in an agreement that you had with these other persons or the persons that was allegedly there?
To my knowledge, conspiracy was like I agreed to just basically premeditate to just string or armed robberies and all of that stuff. So just after it was bought, I didn't agree to like commit a string of armed robberies on families that's in their homes and all of that stuff.
Okay. Are you saying these things just happened? Some of them happened with you and some of them happened without you?
No, I'm not saying none of them. I didn't never rob a person going in their house. Never rob nobody at home.
Okay. Well, if one of the elements of such as we're talking about is an agreement, are you acknowledging that there was an agreement and are you saying you just didn't participate in it?
No, I ain't never really get into this. You know, I came home, so before I got in trouble when I was 18 or whatever, I had left for a while. So when I came back, them was the friends that I knew from back then. So whatever they was into, I didn't stop hanging around them or whatever. I really didn't know. I came home, I was out for 5 months. So I really ain't know what was going on back then. But like after I don't know, man.
Okay. Well, we'll try and get into a little bit more detail so that you can try and explain yourself, all right?
Yes, sir.
Okay. One of probably the most important aspects of this case, wouldn't you agree with me, is what happened allegedly on March the 3rd, 2015, or actually March the 5th, 2013. Do you know what I'm talking about over on Oak Drive?
Yes, sir.
Okay. Well, that's been quite important to you in terms of your admission or lack of admission or denial of participation in that. Isn't that correct?
Correct.
And what is your response to the allegation that you were there and participated in that event?
Well, these Don Diego Adams and Robert Williams is cousins, so they not about to sit up here and say that he did it or my cousin did it. Or a name came up about Harry, whoever Harry is, who a cousin, which I supposed to have been driven to a robbery on Eileen Street. They not about to say he did it either. And as he come up here and y'all ask him what was his last name, he not gonna give you his last name because he don't want you to even. That's his family. They not gonna say that. If one of them did it, they not gonna come up here and say that my cousin did it or my cousin Diego did it. They just and they pick me for whatever reason to get their plea agreement over.
Okay. So is it the essence of what you're saying is you did not attend or participate in what happened as Judge Berg has testified to on March the 5th, 2015. Is that your testimony, sir?
Yeah, I didn't participate in that. I wasn't even there when that stuff happened.
Okay. And if you wasn't there, you must have been someplace else. Wouldn't you agree with me on that?
Yes, sir.
And where is it that you say that you would have been during the period of time that this might have happened, or did in fact happen?
I was on Puritan, 375 Puritan. That's
and what is there?
I had a friend of mine that lived over there on Puritan.
All right. And you know
I was living over there too at that time.
Okay. Well, you know that is a distance, must be a distance away from Judge Berg's house, correct?
I really don't know.
All right.
How close.
You have no idea how far the distance was?
No, sir.
Okay. Did you have a cell phone on that date and time?
Yes, sir, I did.
Okay. Was it activated?
Yes, sir.
And were you talking to people from time to time on that cell phone?
Yes, sir.
Okay. But you understand that you were alleged by Mr. Williams that he was a direct participant in going up to the house of Judge Berg, do you not?
Yeah.
You understand that?
Yes.
And do you also understand that he has specifically identified you
yes, sir.
as the person who went up there to Judge Berg, confronted him, talked to him, was up on his porch, and tried to seek admission into Judge Berg's house? Do you understand that that's what he has said?
Yes, sir.
And what is your response to that, sir?
Well, as we all know, this guy did a lot of whatever he did, and he knew that you came to me and told me that they said, you know, if you give us information on this could benefit you or whatever. And I told you I didn't have no information on it or whatever. So assumably they went to him and said that too. And you know, he on the phone saying he think he gonna get 50 years. So his plea agreement, I don't know if y'all knew, but part of his plea agreement was...
Let's have a specific question and answer.
All right, Judge.
Not a narrative.
Thank you. My specific question for you is, sir, What is your reaction and response directly, yes or no, if you would please, to the fact that Mr. Robert Williams claims that you were the person who confronted Judge Berg and did what Judge Berg alleges was done to him on March the 5th, 2015? What is your direct reaction as to the fact that you did that?
My direct reaction was that he's lying.
Okay. And if he's lying, what directly does that mean in terms of your representation to this jury about your behavior?
No, honestly.
Did you do this, sir?
No, sir, I did not.
Well, why can't you directly say it?
I was confused by the question.
Okay. Do you understand the question now?
Yeah.
What is your answer?
No, I did not participate in that.
You did not shoot Judge Berg?
No, sir.
Okay. And you were someplace else?
Yes, sir.
Were you in the car that evening?
No, sir.
You've heard the testimony of how the persons ran back to the car, is that correct?
Yes, sir.
Had you ever been in that car before?
Yes, sir, I did. Been in
Going to various places?
No, I ain't had no car, so it be times I'll call him and see if he in the area and tell him to stop and give me something to eat, and I'll pay him when he get to me or whatever. So, or he'd probably take me to give me something to eat.
Okay. Well, you've also heard about going to jewelry stores or a jewelry place where things were pawned. Isn't that correct? Did you
Yes,
go
sir.
in that car to places with people who were pawning jewelry?
No, not pawning jewelry, but the jewelry store in Roseville, I went out there.
Okay. Well, let's go back to Oak Drive. Okay.
All right.
You heard him directly say that you were in that vehicle and that there was a decision amongst the persons in that vehicle to do something with that white man who was taken in or out of his trash can, or a guest that had been in his house. Do you understand that?
Yes, sir.
What was your participation or presence in that event once again?
I didn't know nothing about that stuff until I got apprehended, and you was and I synced it in my discovery or whatever, and then you was asking me about it. I didn't know nothing about it at the time.
Did you hear about the discussions afterwards, allegedly, that there was a judge shot and was out in the news, and that you had made a statement that you hoped that no one was going to rat you out and collect a reward for such as that?
No, sir.
Did you participate in any conversation like that?
No, sir.
Did you have any fear about that?
No, sir.
Okay, did you ever admit to any law enforcement agency or officers that you in fact did participate in the incident that we've described fully at Judge Berg's residence?
No, sir.
Okay. And you've been steadfast in that?
Yes, sir.
And you've never told anybody to the contrary, is that correct?
I never told nobody.
Okay, did you ever feel like you were offered anything to say that if you did and implicated other persons that there would be leniency or something like that for you?
I mean, you came and told me that I could get a plea deal if I had an opportunity to blame that on somebody if I wanted to blame somebody, I had no information to. I don't know what type of gun this man was shot with. I didn't know where it happened. It just say Oak Drive on the paper. So I couldn't provide certain information to even blame it on somebody.
I see. But you did feel that the possibility could have been offered, is that correct?
Yeah, it could.
And who were the persons, if you know, made those offers, and are they in the courtroom at this time?
Detectives in the prosecution.
I see, okay. And was that during interrogations that you sensed that?
No. I mean, honestly, to be honest, I've been a little rude to the detectives because I was like, honestly, to the Stewart family, like, I did use your card or whatever, but honestly, I didn't participate and going in your house. If I would have known that your house was that close to my home, I would have never let. And just to, he say that I never had dreadlocks at that time. I'm only wearing.
We just by question and answer.
I think this is a narrative now, Mr. Williams.
I understand completely, Judge. Oftentimes a witness goes and I didn't want to cut him off, so I'll understand better. Okay. Now, you mentioned hairstyle right now, and of course hairstyle was an important part of this case, and because although there was some allegation that the persons were trying to hide their identity, you understand that?
Right.
And that you were specifically pointed out because you had a certain style of hair called dreadlocks. Are you familiar with that?
Yes, sir.
Would you mind telling, for this record and for your lawyer, what dreadlocks mean?
Well, dreadlocks is something. It's a hairstyle that you can't take out unless you cut your hair off. That's the only
You
thing.
mean you have to be bald to start off with dreadlocks?
No, it's like, no, I'm saying like what they are. Dreadlocks is like a style where you twist them up and eventually they lock and you can't take them out unless you cut your hair off. That's to my knowledge.
I see. And after January 2015, did you ever have your hair in the fashion of what you call dreadlocks?
No, I never had dreadlocks.
Okay. So, if someone identified you as participating in any event of any nature involving the charges against you, you deny having had dreadlocks. Is that correct?
Yes, sir. I still don't have dreadlocks,
All right.
sir.
Okay. Let's talk about leaving now the scene at Oak Drive and other incidences. You know that guns have been talked about in this case, have you not?
Yes,
and
sir.
one particular type of gun in particular, and one feature of a gun in particular has to do with a laser beam. Do you understand what I'm talking about?
Yes, sir.
All right. What has been your experience, your personal knowledge and possession of a firearm since you've been out in January of January 2015, sir?
Well, I bought a firearm in February. It was a Glock 23 40. And I ended up buying a laser that can attach to it or whatever. And I had a 9mm Luger they found in my house. Both the guns that they had up here, them was my guns in my house.
They were your guns?
Both of them. Yeah.
All right, go ahead.
Them the only two.
All right, yes, okay. What, if any, participation in any robberies or any illegal activities which we've been hearing about for the last week and few days, did you use personally of either one of those guns?
The stuff I did with the in Roseville, I did, but like a false robbery where some old man was robbed with a laser. I didn't even know nothing about that case until, well, I was being accused of it, you know, because he was saying, you know, a laser or whatever. And they found the gun with a laser in my house, but I didn't. They took my gun out of my house without my knowledge.
How about the shootout with as the car pulled off from the curb? Did you have any participation in that event and or use a gun with a laser on it at that point?
No, sir.
Okay. How about the situation directly involving Mr. and Mrs. Stewart? Did you have participation in that event?
No, sir. I was on Joy Road, ended up calling somebody to take me home or whatever. And while I was riding with that female, Denise Russell, taking me home, she got a phone call from, I think it was Robert or Diego, something like that. So I go over there. The card was handed to me, but at that particular time,
All
I
right,
didn't
let's
know.
talk about that directly. Do you deny that that is you, shown in a video, attempting or using an ATM machine?
No, I'm not denying it.
Okay, that was you, is that correct?
Yes, sir.
Do you have any idea where that card came from personally?
At the time, I didn't know where they got it from, but I knew something. I knew some. If I was supposed to have go to the ATM to you, I knew something. I'm not gonna say that I didn't know it came from someplace, but I just knew. I just didn't know it came from a robbery that happened on Hill. I knew something was up with the card. I just didn't know where it come from. I just
Were you able to get money or retrieve anything from it?
Yes, sir.
And did you get a PIN number?
Yes, sir.
And somebody provided you that?
Yes, sir.
Who was that person?
Diego.
Okay. Don Diego Adams, is that who you're referring to?
Yes, sir.
Okay. Is there any other time that you had a situation whereby you used a credit card which was not yours at an ATM or a like machine?
No, sir. That was the only time I used the ATM.
Okay. Did you ever go into someone's house forcefully with or in conjunction with any of the other persons that we've talked about? Robert Williams, Timothy Russell, or Don Diego Adams?
No, I never did a robbery, like as far as like going your house stuff, like in the house. I never did that stuff.
Well, there are two businesses that have been testified to, and I think have you acknowledged responsibility and involvement in the jewelry store in Roseville?
Yes, sir.
Yes, Judge. How about the incident at a Family Dollar store somewhere in Detroit?
No, sir. I never.
That was not you?
No, sir. I did a robbery in Roseville. That was it. When I got out of prison December, so I was still a little shaken up about going to jail. So I ain't started doing it till I got broke.
Until you got broke, and it was
until I lost my job.
Okay.
So
are you talking about your economic situation?
Yes, sir.
What can you tell me about the 9mm Ruger, sir?
I never had a 9mm Ruger. I had a all-black 9mm Luger that they got and brought up here today.
Okay. And what can you tell me about a .38 caliber pistol?
I never had a .38.
Okay. And how about a .45?
I never had a .45.
Okay. Let's go back to your involvement in the agreement. There has been, by you today, a suggestion, I think, and you correct me if I'm wrong, that you did participate in some things in an agreement with the other parties. Is that true or not true?
Not true.
Okay.
After so long,
rather than just give me a narrative,
yeah.
Do you feel that if you were with them and they did something, it was not because it was an agreement, but it was just the spur of the moment? Is that what you're trying to allude to?
Yes, sir.
Okay.
No, sir. Hold on. Can you repeat that question?
Sure. I think you said you didn't enter into an agreement, correct?
Yes, sir.
But there were things you did do with these persons, correct?
I never robbed nobody with Diego, Robert Williams, or Timothy.
Well, okay. Well, would you like to speak directly about the event in Roseville at the jewelry store? Who was there with you on that time, sir?
To be honest, sir, I'm going to be honest with you. I'm coming forward today with an idea. I'm going to give somebody else their own opportunity to say what I'm just speaking on what I did, sir.
We have not a volunteer response. I'd ask to be stricken.
Well, it's the questioner's prerogative, but the notion is, the question has been asked about the Roseville robbery, and Mr. Smith has to answer any relevant questions regarding that. You can withdraw the question if you want, Mr. McWilliams, but Mr. Smith, you need to understand that you're having admitted that you did the Roseville robbery. You may be asked a bunch of other questions about that.
All right.
You open the door to me. Okay.
And you also understand you're subjecting yourself to cross-examination about all of these events, do you, sir?
Yes, sir.
Are you prepared to go through that today?
Yes, sir.
All right. You know that your house was searched, do you not?
Yes, sir.
And you know that various photographs were being taken of you at ATM and or at gas stations in and out of those premises, correct?
No, sir. I used the ATM one time, and that was on 8 Mile and Woodward.
Okay. And that was the only time?
That was the only time.
Okay.
Not on no other pictures on.
As to the charge of conspiracy, are you pleading guilty or not guilty?
Not guilty.
Okay. As to the charge of assault with intent to commit murder upon Judge Berg, are you pleading guilty or not guilty?
Not guilty.
With regard to the charge of being a person who was not lawfully in possession of a firearm, what are you acknowledging or not?
I did have possession of a firearm when I wasn't supposed to.
All right. And would that also include the fact that during the course of the event at the jewelry store that you did have possession of a firearm during the course of that robbery?
Yes, sir.
Okay. And generally, everything else you are denying. Is that correct, sir?
Yes, sir. I never did no house, family stuff, none of that.
Now, you've written out a lot of different questions that are listed in these various pages. Isn't that correct?
Yes, sir.
Now, in your general denial of things, each one of those, although not specifically asked, have been in fact covered as far as what you want to impart to this jury. Isn't that correct?
No, sir.
Okay, which one, what is it what topic was it that you would like to specifically address?
Well, I'm going to just well, it was just...
No. Okay. All right.
Direct question and direct answer. No
All right.
speeches.
Okay.
Nope.
You have, sir, would you agree with me that you have correctly stated your position as to guilt or innocence of these charges?
Yes, sir.
And that you have denied the ones you want and you have admitted the ones that you want?
Yes, sir. I'm denying the ones that I didn't do, sir.
That's correct. Thank you very much.
Once again,
So, Mr. Smith, you got out of prison in December of 2015.
Yes, sir.
I'm sorry, 2014, correct?
Yeah, 2014.
And that was for home invasion, right?
Yes, sir.
Breaking into people's houses, right?
Yes, sir.
You got out in December, January, December, you get back in the neighborhood where you're from, right?
Yes, sir.
You're friends with Timothy Russell, right?
Yes, sir.
From Highland Park High School, right?
Yes, sir.
You're friends with Robert Williams from Highland Park High School, right?
No, sir.
You're not friends with Robert Williams?
Not from high school. Robert stayed like three blocks over from my old house.
Okay. But how long have you known Robert Williams?
A year after I met him, since I was like 15.
15 years old. How old are you now?
23.
So that's 8 years? Yes?
Yes, sir.
When you got back out of prison into your neighborhood, did you see Robert Williams in the neighborhood?
I wasn't living over there no more.
Did you see Robert Williams when you got out of prison?
Yeah, I seen him.
Did you know him by Nunu?
Yes, sir.
Okay. Was he a friend of yours when you got out of prison?
Like an everyday friend?
Was he a friend?
Yeah, he was somebody I talked to.
Okay, you would talk to him from time to time? Yes?
Often.
Okay, often.
Yeah.
You told your attorney that when you got out of prison, you didn't want to go back to prison, right?
Correct.
But in February, you bought a handgun, right?
Yes, sir.
You bought a Glock 40 caliber handgun, right?
Yes, sir.
You can't have a handgun when you're on parole, can you?
No, sir.
That's a violation of your parole, right?
Yes, sir.
You can get what's called flop for that, right?
Yes, sir.
You can go back to prison for that, right?
Yes, sir.
Because you bought a handgun anyway, right?
Yes, sir.
So when you said you didn't want to go back to prison, you broke the law by buying a handgun, didn't you?
Yes, sir.
So that didn't concern you, did it, at that time?
Not guns. I was talking about like.
But in fact, you didn't stop with one gun, you bought a second gun too, right?
Yes, sir.
You bought, not only did you have a Glock 40 caliber handgun with a laser pointer, but you bought a gun, a 9mm gun too, correct?
Yes, sir.
And you kept possession of those guns, 2 guns, even though you didn't have a job, right?
Yes, sir.
You had 2 guns in your house for protection.
Yes, sir.
Would you carry those guns with you?
No, I just take pictures with them and put special attachments on them, flash them.
You take pictures of them, put on your phone, that sort of thing?
Yes, sir.
Well, you didn't carry them with you on the street?
No, sir.
You told your friends you had those guns, right?
Yeah, they knew I had them. Yeah.
So Robert Williams knew you had a gun, right?
Yeah, I showed it to them.
Timothy Russell knew you had a gun, right?
Yes, sir.
And Timothy Russell and Robert Williams also had guns too, didn't they?
Now, yes, I see now. Yeah, yes.
Okay, well, did you see at the time they had guns?
No, sir.
You told Mr. McWilliams they were involved in all kinds of stuff that you weren't involved in. Robberies, home invasions, that sort of thing. You didn't do any of those things.
No,
right?
I'm not saying, at the time I'm not saying they was involved in robberies. I didn't never go out with them whenever, I never even knew what, at the time, what they was doing.
So it's your testimony under oath that you didn't know what they were doing when they were robbing houses. Is that your testimony?
Yes.
It's your testimony under oath that you weren't involved in any planning or execution or robbing people in their homes. Is that your testimony?
Yes.
Okay, you had nothing to do with that.
Nothing to do with that.
Okay. Did you know that Robert Williams and Timothy Russell and Don Diego Adams were doing that?
Not until I got apprehended. Well, at the end, yeah, yes.
At the very end. We'll get to that in a minute.
Yes, sir.
So you didn't know until the end of this whole conspiracy that they were actually involved in robbing places, right?
Yes, sir.
That's your testimony under oath.
Yes, sir.
Okay. Now, you testified that on Hilldale you got a call and someone picks you up, the DCA picks you up and took you to an ATM and gave you your credit card and said use it, right?
Yes, sir.
And we've seen that picture on the TV, on the monitor of you withdrawing money from an ATM, right? That's you, isn't it?
Yes, sir.
That's you using Mr. Stewart's stolen ATM card at that PNC Bank, right?
If that was her car, yes.
Okay. And that was you doing that. You got a PIN number, you took money out, and you didn't have a right to have that, did you?
No, sir.
In fact, you had no business taking that that credit card and using it, right? You knew it was stolen.
Yeah, I knew something was up with the car.
In fact, you were involved in the robbery, weren't you?
No, sir.
You heard in court Mr. Stewart testify, this gentleman right here, in the tie, right?
Yes, sir.
You heard him testify about how he got out of his car and was approached by someone who put a gun to their head, right?
Yes, sir.
And then how 2 other people got involved and came from around the corner, and all 3 were involved in that robbery. You remember that?
Yes, sir.
3 people were involved in robbing him, right?
Yes, sir.
Okay. You heard that testimony, correct?
Yes, sir.
Okay. Any reason in your mind to doubt the veracity of what Mr. Stewart said?
I believe that happened to him.
Okay. No reason for him to come in here and lie about how he got robbed on April 15 in his own house, right?
Right.
Okay. And then you heard Mrs. Stewart testify that not only did at least 2 people come in the house, they took their ATM card, their debit card, personal belongings that were dear to their sentiments, jewelry they got from their mom, jewelry they got from people that are no longer with them. You remember that?
Yes, sir.
You remember that testimony, right?
Yes, sir.
Okay. And it's your testimony that you did not rob those people, right?
Yes, sir.
It's your testimony that all you did was go to the ATM because someone asked you to go to the ATM, right?
Yes, sir.
And you're under oath, right?
Yes, sir.
Okay. And does that oath mean anything to you, sir?
Yes, sir.
What does it mean to you?
I could be subject to another case, perjury.
Okay. Does it, other than being subject to perjury, does it mean that you take it seriously?
Yes, sir.
So when you raise your hand and promise to tell the truth, is that something you take seriously?
Yes, sir.
Okay. Back on November 17th, 2015, were you in this very courtroom?
Yes, sir.
Were you in this very courtroom with me being a prosecutor?
Yes, sir.
With Judge Kenny being the judge?
Yes, sir.
And did you raise your right hand and promise to tell the truth back on November 17th, 2015?
Yes, sir.
And did you tell the truth under oath on November 17th, 2015?
I was forced to say.
That's not my question, sir. Yes or no? Did you tell the oath? Did you tell
Yes,
the
sir.
truth?
Yes, sir.
Did you tell the truth under oath on November 17th, 2015?
Yes, sir.
So when you were asked by the court, can we bring up People's Exhibit 124? Page 51. See the top of the line there? It says, Mr. Smith, you were sworn. You continue to be under oath at this particular time. I advise you of your rights. I've explained to you the deal. And once again, we'll get back to the facts. Back on April 15th, 2015, were you at address on West Hilldale Street in the city of Detroit? Your answer was yes, correct?
Correct.
Next question by the court. And there, did you assist some others in terms by force or violence, taking bank cards or money from residents who lived at that particular location, a woman who later learned was Sandra Stewart? Is that true? You answered yes, right?
Yes, sir.
The next question was, at some point, did you or someone else have a firearm, a handgun? And your answer is yes, I did, right?
Yes, sir.
Okay. That's under oath, right?
Yes, sir.
You testified under oath that you had a handgun on April 15th on Hilldale Street, right?
Yes, sir.
Okay. And what kind of gun was it? Was it a 38, a 45? What was it? And you said, I don't remember. Is that right?
Yes, sir.
Okay. And you testified under oath about you being involved in the people being robbed, right? By force or violence. Isn't that right?
Yes, sir.
Okay.
Excuse
So,
me, but
wait, listen for my questions.
all right.
So, on November 15th, under oath, you said you robbed these people, right?
I said I was on Hilldale when it happened.
You said you robbed these people under oath. Isn't that your testimony?
Yes, sir.
And today in court, you say you didn't rob these people, right?
Correct.
Today in court, you say you had nothing to do with the robbery of those individuals except a credit card, right?
Correct.
The truth is, the only reason you say you were involved is because we got your picture on the ATM machine taking money out, right?
Is that the only reason why I'm saying I
The
wasn't?
only reason you said you were involved in that aspect was because we got your picture on the monitor of you withdrawing a credit card. Isn't
No,
that
that's
true?
not the only way.
In fact, it's true, isn't it, Mr. Smith, that you've denied all along, you've lied and lied and lied to the police about this case. Isn't that true?
I told him I didn't own the gun.
No, that's not my question. My question is, did you lie?
I didn't
again
lie,
and
lie.
again?
No, not again and again and
Okay,
again.
you
I
know,
lied before.
Let's start with the very first thing that you said to this officer right here. Did you tell him the truth about what your name was?
No, sir.
You told him your name was Timothy Russell, right?
Yes, sir.
And that's not the first time you've lied to the police about your identity, is it?
I don't recall. I remember telling
You
him.
want me to refresh your recollection with the police reports? When you've been arrested before, you've used Timothy Russell's name, haven't you?
Yes, sir.
On more than one occasion, correct? Yes?
Possible, yes.
For a home invasion, for armed robberies, you lie and give Timothy Russell's name, not your own name, right?
No, I never gave Timothy Russell name on a home invasion.
Just on armed robberies, right?
No, not even on armed robbery.
Not even on carjacking and armed robbery cases, you never gave his name?
Not that I recall.
Well, how many times have you lied about your own name to a police officer?
Anytime that I owe a lot of tickets, I pretty much not going to tell the police my real name because I don't want to go to jail for my
So
tickets.
you're going to lie to protect yourself, right?
Basically, not to go to jail for my tickets.
So you're going to lie about the very simple fact of a ticket, right? You're going to lie to help yourself out of a ticket, right? How much would you lie to help yourself out of an armed robbery?
I'm not lying about armed robbery.
Oh, you lie about a ticket, but you're not lying about an armed robbery. How much you lie about shooting a judge?
I didn't shoot the judge.
So you wouldn't lie about that?
No, sir. I'm
Did
not
you know
about
he
to
was a
lie.
judge when you shot him?
I didn't shoot him.
Did you know he was a judge when you robbed him?
If I shot the judge, sir, I'd have took a plea agreement, sir.
Okay, you were taking a plea agreement.
With two guys testifying on me, sir.
Okay, because you knew Timothy Russell and you knew Robert Williams, a friend of yours, right? Friends. Friends, right? They know
Yeah, that
you,
was
you know
cool.
them, right?
Right.
Okay. But I want to talk about the police now. When the police first interrogated you on May 24th of 2015, they asked you about the guns and you lied, right?
Yes, sir.
You told them you didn't have any guns, right?
Yes, sir.
Even though you knew that guns were in your house, right?
Yes, sir.
Again, you lied because you knew that if you had a gun, you'd go back to prison, right?
Yes, sir.
So instead of admitting that you did something wrong, you lied to help yourself, right? Yes?
Yes, sir.
Okay, let's do the first clip.
You know what I'm saying? But I never pointed no gun at nobody and took their shit.
All right, now that's you saying that you've never pointed your gun at anyone and robbed them, right?
Yes, sir.
Now, you told the police that the first thing out of the box, I didn't rob anybody, right?
Yes, sir.
And that was a lie, wasn't it?
Yes, sir.
You lied to the police about robbing someone, right?
Yes, sir.
And you lied because you wanted to help yourself out of a bad situation, didn't you? Yes?
Yes, sir.
So you lied about committing robbery. Let's bring up People's Exhibit. number 393. This is 4 days before you're interrogated by the police, right?
Yes, sir.
And this is 4 days when you tell the police, I've never pointed a gun at anyone and demanded that they give me property, right?
Correct.
And here you are on the television, right there with a gun in your hand, right?
Yes, sir.
So again, you lied to the police about that, right? Yes?
I didn't never lie to them about this right here. I was never even...
Wait, let's play that clip again.
You know what I'm saying? But I never pointed no gun at nobody and took their shit.
So when you, that's your voice, isn't it?
Yes, sir.
And that's you saying, I've never pointed a gun at nobody and took their shit, right?
Yes, sir.
And that was a lie because 4 days before then, you pointed a gun at that jewelry store owner and took his merchandise, right?
Yes, sir.
So that was a lie to the police, right?
When I first came in, they said... Well, that's what I originally thought I was getting arrested for. It was for that, because it had just like happened or whatever. And when I first came in, they said, what do you know about robberies and shootings going around Detroit? Then that's when I realized I wasn't in there for that. So at that time, I felt like, why would I just come out and say that if I don't?
So you felt at the time it's okay to lie then, right? They don't know nothing about Roseville. I'm just going to lie about it because they don't know, right?
Yeah, that's what I thought.
Yeah, because it helps you to lie, right?
But if they would have told me
Smith,
about the
listen to my
Roseville...
question. It helps you to lie because they weren't asking you about Roseville, were they?
Right, I wasn't.
So you lied about not robbing people, right?
Correct.
Yeah.
Correct.
Now, you lied to them about guns, too, right? You said you didn't have any guns, right?
Yes, sir.
Can we play a gun clip, please?
Everything's so personal.
I ain't got no gun. I don't have no gun.
So your friend's not gonna be on any of those guns?
It was more than one gun there?
Your friend's not gonna be on none of them?
No. Friends ain't gonna be on that one.
Does your grandmother know that there's all kinds of guns in her house?
No, I didn't even know it was all kind of guns.
Well, that's rude to her.
So, there you are saying that you don't have a gun, right?
Yes, sir.
Did you ever tell the police that maybe it's your grandmother's gun?
Yes, sir.
So, when they asked you about guns that you knew you owned, not only did you lie about having them, but you lied and put the blame on your grandmother?
No, I didn't lie on my grandmother.
No, you said maybe they're her guns, right?
I never said that they was her guns. I said they probably... I was saying I didn't have no knowledge they could be hers. That's what I said.
Oh, okay, so you said you lied about not having guns, and you said, oh, maybe they're my grandmother's guns.
But
right?
I told them that the Glock 23 was not her gun.
Yeah,
but I also told them it wasn't mine, too, so yes.
Yeah. But my point is, sir, not only did you lie about owning those guns, but when pointed about which guns they are, you said, maybe they're my grandmother's, right? Let's hear that. Look.
Never gave me no car.
Is there any guns in your house?
No, unless my grandma got a gun upstairs.
Was your grandma allowed to have a gun upstairs?
I don't know. I don't know if she have a gun. I'm saying unless she had one upstairs. That's what I'm saying. I don't know if she had one upstairs. I don't ask her if she had a gun.
Okay. Well, you know we did a search warrant at your house that night too, right?
Yeah, I'm pretty sure y'all did. I seen them going in.
Right. Do you think they brought out any guns?
I don't know. They ain't tell me they did.
So again, when you get caught with incriminating evidence, first you lie, and then you blame somebody else, even your own grandmother, right?
No, sir.
That's not what you said. All right. Now, you indicated when you were being interviewed by the police, not only did you lie about those instances, but you also said you didn't rob anyone, right?
Correct.
Yeah? Okay. Did they ever ask you about your grandmother being robbed, about how you would feel if your grandmother was robbed? Did they ever ask you that question?
Yes, sir.
And what did you tell them?
I think I said I'd be hurt or something like that.
Why?
Because this is my grandmother.
But you get hurt, right?
Yes, sir.
And you said to the police that if someone gets robbed during a robbery, people can get hurt, right?
Yes, sir.
You'll acknowledge for me, Mr. Smith, won't you, that during an armed robbery with an armed gun, the loaded gun, people can get hurt, right?
Yes, sir.
Especially a caliber gun, big caliber gun like a 9mm, 40 caliber, or 45 caliber, right?
Right.
Those guns are designed to kill people, aren't they?
Correct.
And so if you shoot someone, you could kill them, right?
Correct.
And if you shot someone from 2 or 3 feet away, that person could die, right?
I guess it
Well, don't guess. It's true, right? You just told me that you could kill someone with a gun, right?
depends depending where you shoot them at.
Okay. Would it matter? I mean, if I got shot in the arm or the leg or the chest, I could still die from being a gunshot, right?
Yeah, if it hit an artery or something.
Okay, so if someone points a gun at someone else and pulls the trigger, you agree with me that person could die, right?
Yes.
Because it's serious, isn't it?
Correct.
Especially if I'm 2 to 3 feet away from that person, right?
Correct.
So someone 2 to 3 feet away from someone with a handgun like a 40 caliber or 45 caliber and pulls the trigger, the victim could die, right?
Correct.
Okay. And you know that, don't you?
Yes, sir.
And you have not one but 2 of those handguns back in March of 2015, right? Yes?
Did I have those 2 handguns in March 2015?
Yeah.
Yes, sir. I did have those 2 guns in March 2015.
So you know that those guns are dangerous, and you had not one but 2 of them, right?
Correct.
Okay. Now you told us that you were not part of any of these planned robberies at all with Don Diego Adams and Russell and Williams, right?
Correct.
You didn't have any knowledge about them robbing people. You had any knowledge about them doing walk-in robberies, right?
Right.
Now you heard them testify to the contrary, didn't you?
Yes, sir.
You heard Mr. Adams and you heard Mr. Williams say that it was your idea because you didn't want to get hurt breaking into people's houses, right?
That was part of a plea agreement to testify on me, sir, so that's what
Well,
they
their
did.
plea agreement was to tell the truth, right?
Yeah, that's what their plea agreement said, yes,
Okay.
sir.
And you heard them testify that it was your idea because you didn't want to break into people's houses anymore to make a living, right?
I guess, yes,
You
sir.
heard that, didn't you? Yes?
I think, yes. I think.
And it's your testimony that that was not true, right?
It's not true.
Okay. So, did you ever talk to either Mr. Russell or Mr. Williams on his phone, on their phones?
Yes, sir.
Okay. Did you ever send them text messages?
Yes, sir.
Okay. And did they ever send you text messages?
I never text Robert Williams at all. He'd call from now on, but sometimes I text him, probably ask him where he at.
How about Mr. Russell? Did you ever text him?
Yes, sir.
Okay. And were you texting him in January?
I mean, if you pull up the text message,
Well, I'm asking you. Did you ever send him a text in January?
in January, I don't even believe I had a phone in January, sir.
Okay. Well, let's start with People's Exhibit number 180. Let's go to page 7. Do you recognize who those people are?
Yes, sir.
And who are those people?
That's the day I came home. That's me and Timothy Russell.
Okay. And that's you wearing that Nike sweatshirt that we saw not only in the search warrant, but also in the video of you in the PNC, right? Wearing that jacket.
I can't say that that's the same jacket, but it's, I had a cut.
How many Nike jackets do you have like that?
Probably had like 3 or 4 different colors. I had 2 of
How
the
many
same.
blacks do you have like that?
2.
2?
Yeah.
And you heard the testimony that we only found 1 in your house, right?
Yes, sir.
Where was the other one back in May of last year?
By again, warm, ain't no telling. I probably left it somewhere at somebody's house or anything. I don't know, but I had 2 of them.
You saw Mr. Williams wearing that in some video of some ATM stores on April 15th, didn't you?
I guess if that's a Nike, I guess, yes.
Did you give it to him to wear?
No, sir.
Did you just take it off you?
Sir, everybody had those. It's Foot Lockers. Everybody had those. A lot of people had those jackets, sir. They only $25, $30 a month.
Well, you heard him testify that you gave him that gun. You gave him that sweater so he could go and cash out those ATMs on April 15th. The same one you're wearing in the PNC video. You heard that testimony, didn't you?
So what was he wearing when he robbed the people, sir?
Answer my question, Mr. Smith. Did you hear him
I
testify
guess.
that?
Yeah, I guess.
Did you hear that? Yes?
Yes.
And you saw the pictures, right?
Yes,
And the pictures of the same jacket, right?
It can't be the same jacket, sir. It looks
Can
similar,
we bring
but
up that? I'm not sure what exhibit number it is. Just bear with me for a second, please. Hope that's not it. Okay, can we put 144 beside the photograph of him and Mr. Russell? You'll agree with me, Mr. Smith, that the jacket that Mr. Williams is wearing there is similar to the one that you're wearing in the photograph of Mr. Russell?
correct.
Okay, all right. But you're not saying that 100% that's your jacket, right?
I know 100% is not. I didn't take no jacket off and give it to him that day.
Okay, so it just so happens that the jacket he has is similar to the one that you have.
Robert Williams liable to have had a jacket. Everybody had a jacket like that, sir.
Okay. Now, you said that you may have sent some text to Mr. Russell in January. Is that right? Yes?
I don't think I had a phone in January, sir. I didn't.
Okay, all right. But you did contact him on his phone, right? Mr. Russell?
Yeah, from my grandmother's
From
phone.
time to time. And he knew you as Kev, right?
Yes, Tim knows a lot of kids, sir.
He knows a lot of it. We'll get to that in a minute. So, he knew you as Kev, correct?
Yes, sir.
Okay. And you've told Mr. McWilliams that that was your street name or nickname, and that's how they called you, right?
Correct.
Okay. And I'm going to show you page 15 of People's Exhibit number 180. Can you enlighten that a little bit? Magnify a little bit? Do you see an incoming text message from someone identified as Kev?
Yes, sir.
Okay, and you see the message? If that go through, I'm going to give my mama $100 to see her car for 2 days. I'm going to hit a lick to get some more money, right?
Yes, sir.
Okay. What does hit a lick mean?
Street term.
Yes.
It could be any type of illegal activity.
Okay. You've heard that term before?
Yes, sir.
Okay. Let's go to page 17. This is another text from Russell, not for you though. It's from Nunu. You recognize that? Nunu being Robert Williams?
Yes, sir.
And that would be in Mr. Russell's phone because they were friends, right?
Yeah.
Okay. Not unusual to see that, right? Correct?
Right.
Let's go to page 19. Now these are text messages that are between someone named Kev and Mr. Russell on about January 20th of 2015. You were out of prison at that time, right? Yes?
Correct.
You were friends with Mr. Russell at that time, right?
Sir, my parole agent confirmed that wasn't my number, sir.
That's not my question, Mr. Smith. Listen to my question.
I knew. Yes, I was
You were
out with
friends-
him.
You were friends with Mr. Russell, right?
Yes, sir.
Okay. And you were communicating with Mr. Russell, right? Yes?
Yeah. Yes.
Yes? Okay. And I want to call your attention to this one in the middle here that's indicated by 505. Can you blow it up? 50, the one in the middle? Can you see that, Mr. Smith?
Yes, sir.
Now, this is a text message from someone named Kev, right?
Yes, sir.
And it talks about little Diego still got the car,
Correct.
and that's Diego Adams, right?
I guess, yes.
Well, don't guess. Do you know little Diego is Don Diego Adams?
Well, I knew him as Diego. Now I know him as Don Diego Adams.
Okay. And you'll agree with me that this is a text message from someone named Kev to Mr. Russell talking about Don Diego and his car, right?
Correct.
Okay, and whether he still got the car, right? Yes?
Correct.
Okay. Let's go to page 20. This is the same time period, a few days later. Text messages from someone named Kev saying, bro, I need the money for the mag. What's a mag?
It's a magazine.
For a gun?
Correct.
Okay. Again, this is a text message from someone identified as Kev to Mr. Russell talking about a magazine for a gun, right?
Correct.
Okay. Now, it's your testimony, that's not your cell phone number, right?
Sir, I had got that phone number in March, and y'all officer Laura Stackhouse can confirm that. I told her in the report when I...
This number is yours.
Yes, I ended up buying it from somebody in March. It's in y'all report.
And then you're talking to him about getting a mag for a gun, right?
No, sir, I'm not texting him from that phone at the time, sir.
Well, this is your number, right?
In March, that was my phone number. I bought it from Randy.
Okay. And that's the identification of Kev, right?
Yes, sir.
So somehow, this comes up from you, someone named Kev, correct?
So,
Yes, Mr. Smith?
if this is my new number and he changed the name under Kev, it's going to automatic go back to all the old text messages, and the name's going to be under Kev.
Okay. So again, someone by the name of Kev that knows Mr. Russell and knows Don Diego Adams sent this text message talking about a magazine, right? Yes, Mr. Smith?
You said this. Yes, sir.
And
Had
this is
to
the
be.
number that's assigned to you in
In
March
Yes, sir.
of 2015, correct?
Yes, sir.
And then it changed that name back to Kev because the numbers line up, right?
Changed it back to Kev because it's my number now.
Okay. So what happened to the other Kev?
If you pull up all 3 contacts in the phone, you will see 3 different Kevins with 3 different numbers like y'all showed the other earlier, sir.
So when this number is put in, this is your number, right?
No, yes.
And it replaced the previous number that you gave Mr. Russell, right?
Can you repeat that?
You just told the jury that when you got this phone in March,
Right.
correct, and you put the new number in and assign it to Kev, that it'll replace the old numbers that were texted him from the same person.
What I'm saying is,
Mr.
if
Smith,
it,
listen to my question. Isn't that what you said? Yes or no?
I'm trying to get what you're
Answer
saying,
my
sir.
question, Mr. Smith. Yes or no?
I'm trying to get what you.
Mr.
Can you
Smith,
repeat it?
answer
Can you
my
repeat
question
it?
is this. You testified a minute ago, didn't you?
Yes, sir.
And you told this jury that this is your number that you got in March.
Correct.
Okay. And you told us more that when Russell put that into his phone, that the previous numbers assigned to Kev changed to this number. Isn't that what you said?
No, that's not what I'm meaning, sir.
Well, you just told the jury that when you got this number in March, you gave it to Mr. Russell, right?
Correct.
You put it in his phone.
Correct.
And then the name Kev is assigned to that number, right?
Correct.
So the text messages that were still in his phone assigned to you, even though that was before the number was assigned,
It'll be Kev, yes,
it would
sir.
be Kev.
Yes, sir.
So your testimony is that even though you didn't get this phone until March, when the number was put in March, it reassigned your previous number from Mr. Russell to this number, right?
Correct.
So that text that you sent him on January 29th from another phone talking about a magazine assigned to you, right?
Correct.
Just like, we go back to the last page, just like when you said, I'm about to hit a lick, was assigned to the name Kev, right? Because in January, the page before that, one before that, page 15. Here it says, I'm about to hit a lick, rob somebody, or do something illegal, right, to get some money, right?
Correct.
Go back to who it's from. This number assigned to an individual like Kev, right?
Correct.
That's you, right?
I never had that number, sir.
That's not my question. That's you, isn't it?
No, sir.
That's not you.
No, sir, it's not.
So some other Kev that knows Mr. Russell and knows Don Diego Adams, back in January of 2015, is talking to him about magazines and guns and hitting licks, but not you. Is that your testimony?
Correct.
So some other Kevin is the one who was in this plan to rob people in their homes, correct?
I don't know if that's what they hitting a lick could be dice, breaking into a house, it could be selling cars, it could be hitting a lick, could be hitting a lick is anything quick money, that's what it is. It don't necessarily have to be robbing or something like that.
But you'll agree with me that this is evidence that Kev and Russell and Don Diego Adams are involved in a plan to do illegal activity, right?
Yes, sir.
And this is evidence of that, right?
I guess, yes, sir.
It's pretty good evidence, in fact. I'm going to hit a lick, right?
Correct.
And the name Kev is there, right?
Correct.
And your testimony is that's not you, right?
Correct. If you
That's some other Kevin, right?
Correct.
You heard Don Diego Adams say he didn't know no other Kevin but you.
No,
right?
sir. If you would have asked him, he would have told you
He
that
asked
he
him that
know it.
question. Did you hear his answer?
No, sir. I never heard that
Okay.
answer.
So it's your testimony some other Kevin is involved in this conspiracy, just not you.
I'm not saying that other Kevin is involved in conspiracy. I'm just going off what the text messages see, sir.
My question, sir, is there's some other Kevin out there in the world that is friends with Mr. Russell, Mr. Don Diego Adams, and Mr. Williams who are having these conversations about hitting licks, but it's just not you.
Correct.
Even though when you got your phone and gave him your new number in March, it went back all the way to January and changed the name to Kev, right?
Correct.
The same name that's on here, right?
Correct.
Okay, all right. Let's talk about the conspiracy. You said you're not part of the conspiracy. You had no planning in any of those robberies. Is that what you're saying?
Street robberies? No, sir, I did not.
Okay, you did not have any planning of those robberies?
Robbing families in the house, no sir, I did not have.
Okay, let's talk about the jewelry store.
Correct.
You testified that you were involved in that jewelry store robbery, right?
Correct.
Did you just happen to be in Roseville on that day when they happened to be robbing you? You say, hey, I'll go along with you, just on the spur of the moment as you told your lawyer? Is that what happened?
I don't know if Warren would be considered. My friend
Roseville?
stayed over there. Yeah, Warren that's close by. My friend stayed over there, so.
So you just happened to be in Warren and just happened to be going looking for engagement rings? What were you doing in Roseville?
It's close by my friend's house in Warren, Michigan.
So just driving around and happened to be in Roseville?
Correct.
And you had nothing
Not
better to
just
do?
so happened I ended up riding past it.
I'm sorry?
I ended up riding past it and saw it or whatever.
And decided you're going to rob?
Correct.
Just on the spur of the moment?
No, sir. Everything is anything.
Hold on, Mr. Smith. There's no question.
That's it.
So it's your testimony that you and Mr. Williams and Mr. Russell and Don Diego Adams and Alan Corman did not plan that robbery?
No, sir.
Is your testimony that that wasn't wasn't Robert Williams' plan to rob that jewelry? Is that your testimony?
No.
You heard Robert Williams testify that was his idea, right?
Correct.
And that's not true, is it?
No, sir, it's not
Just
correct.
out driving around and decide to rob a jewelry store?
Sir, honestly, Robert Williams wasn't there. I told him about it, and for whatever reason, he told y'all he got to be an eyewitness to say that I was there. He wasn't even there.
He wasn't there. Okay.
No, sir.
So, and you heard the owner of the store testify that two African-American men came up to him outside the store and saw the bleeding and said, I'm going to go get those guys, and took off running, right?
Correct.
Okay. And your testimony is that Robert Williams is making that up.
Robert Williams was not there, sir.
So he's lying when he says that.
Correct.
Okay. So you just told him about that.
I told him about it, sir.
So let's walk through that. You didn't have a plan to rob that store?
I thought about it before I did it.
Okay. So you just went on your own to rob that store. You were with somebody else, right?
Correct.
Alan Corbin, right?
Sir, I'm speaking on me, sir.
No, you're going to have to answer the question.
You were with Alvin Corbin, right? Mr. Smith?
I did what I did, sir.
And who was with you?
I'm man enough to say what I did, sir.
Mr. Smith, answer the question. Who was with you at that jewelry store robbery?
No, I just don't feel. I'm just saying what I did, sir.
No, I understand.
I'm not
what you're
being
saying.
rude.
You want to stick up for your
No, I don't want
your
to.
buddy. That's who it is. But
I don't want to stick up for anybody. I'm just what I believe in is standing up for what I did.
I
I don't want to put
understand
on.
what you believe in. But you decided to get on the witness stand and answer questions.
Correct.
You have to answer any question that's relevant. It is a relevant question when you're talking about admitting to robbing a jewelry store and a charge is conspiracy that you were in agreement. Who are you with? Answer the question.
Who are you with, Mr. Smith?
Sir, I got up here and admit what I said, sir. I'm not finna implicate nobody finna stuff, sir. I'm sorry. I apologize for that.
I don't want you to apologize. I want you to tell the truth.
I'm telling the truth, sir. I want to give somebody. If
Mr. Smith, who went with you with that robbers, the jewelry store to rob? Who's with you?
I'm just saying what I did, sir.
Mr. Smith, who was with you?
I'm just saying if I gotta get kicked off the stand, sir.
You're not going to kick off the stand. We're going to talk about this some more. Who was with you in that jewelry store to commit that robbery?
Ladies and gentlemen, let me step into the jury room just a minute.
All right, jury.
All right, we're outside the presence of the jury. Mr. Smith, have a seat. Mr. Smith, let me say this to you. When you continue to refuse to answer questions in front of the jury,
Yes, sir.
I am going to share with you, in my view, you're burying yourself. All you do is you keep hiding information that the jury is interested in hearing, and that's not helpful. It's not going to help you, but it's your choice. Bring out the jury.
All right.
me see something for a second. May be seated.
Mr. Smith, before we broke, we were talking about the jewelry store robbery on May 20th in Roseville. Do you recall that?
Correct.
You told me that you were with someone, right?
No, I didn't say I was with someone.
You went there by yourself?
I just said I'm manning up to what I did, sir.
Did you go there with someone else?
I went to the jury.
With yourself or with someone else?
Your Honor, I accept whatever I gotta accept for not. I'm just being man enough to say
All right,
what
so
I did. sir.
you're refusing to answer questions. You're refusing to tell this
Just-
jury the truth about what you were involved in, aren't you, Mr.
I'm
Smith?
telling the jury the truth what
No,
I
you're
did.
not telling them the truth. You're telling them what you want them to hear, right?
Alan Corbin is not here at trial, sir.
My question is, sir, when I ask you questions, you're refusing to answer them, right?
No, sir, I'm not refusing that. Sir,
Who else was with you in the jewelry store robbery?
I'm being honest about what I did, sir.
It sounds like he's refusing to answer. Let's move along, Mr.
All right.
We can go forward. It's
Okay.
fair that Mr. Smith is refusing to answer the question.
Mr. Smith, your attorney asked you questions about whether you were involved in a robbery on Asbury Park. Do you remember that?
Correct.
And that occurred on May 8th. I'm sorry. Yeah, the early morning hours of May 8th in the city of Detroit, right?
Correct.
And you said you weren't involved in that, right?
Correct.
Now, you weren't working at that time, were you?
May 8th. No, sir.
Okay. And so you didn't have a job, right?
No, sir.
Okay. You heard testimony from Mr. Williams that in the early morning hours of May 8th, you and he robbed someone and got a Rolex watch, some jewelry, and later that day pawned it and got a substantial amount of money, right?
Correct, sir.
$5,000, right?
That's what you said.
That's a lot of money, isn't it, Mr. Smith?
I guess it's not really.
Not to you? It's not a lot of money?
It's a couple dollars.
It's just a couple of dollars. Okay. Did you send a text message? Did you get a new phone on May 8th?
Was it May 8th? I believe. I don't remember. I know it was in May. I don't remember the exact date.
Exhibit 27, page 15. The same day that couple was robbed in Asbury Park, in the early morning hours of May 8th, the same day Mr. Adams said that you and he went to Ziedman's to pawn that jewelry, you got a new phone, right?
Correct.
And
I guess that's the day.
don't guess, you can see it right there, right?
You say May 8th, yes, sir.
Yeah, okay. And you heard Mr. Williams testify. That's the same day that you and he robbed that couple on Asbury Park, right? The
Yes.
same day that you got $5,000, that little bit of money that you just said a minute ago, right?
Correct.
That's when you got a new phone, right?
I get.
Yes?
Correct.
And then on that same day, on page 17, you sent a text message to somebody saying, I'm about to get a crib soon, right?
Correct.
So the same day that Mr. Williams says you robbed someone, and Mr. Adams says he went to Ziedman's with you to pawn jewelry, and you got $5,000, not only you get a new cell phone, but you text out, hey, I'm about to get a crib soon. Isn't that true?
I remember texting that, sir.
So isn't that true, yes?
Yes, I text that.
So it's true, right?
Yes, sir. I did text that.
Perhaps this would be a good time, Your Honor.
All right. Ladies and gentlemen, it certainly was my expectation and all of our expectations that we would finish today. That's not going to happen. What I am going to do, Mr. Poulan, I'm going to have you remain behind. But ladies and gentlemen, talking with the attorneys, we are going to finish this case Monday morning. I'm going to need you to come back Monday. I'm going to ask that you be back here at 8:30 in the morning. 8:30, we will complete all of the evidence in this case. There will be argument and instructions. You will have the case to deliberate on Monday. Have a nice, we're not meeting tomorrow. Have a Nice weekend. We'll see you here 8:30 Monday morning. Finish it up.
All right.
Len, you can just remain if you would for a few minutes, okay?
May be seated.
You may be seated. You can sit down. Mr. Glenn, we're outside the presence of the other jurors, and I think the record should reflect that when we did pick the jury, you had indicated that you had this very important out-of-the-country trip coming up Tuesday, I think it is, right? And we certainly had every expectation that this trial would not interfere with that. You sent us the note indicating your concern, and in talking with the attorneys, it's my understanding that there's no objection to Mr. Poulan being excused and that he would be one of the excused jurors. Is that right?
That is correct, Your Honor.
All right.
That's correct, Your Honor.
So, Mr. Poulan, I appreciate your being here, and sorry we weren't able to see it through to completion, but what I did want to have you do is to make sure that you not talk with anyone, any of your fellow jurors or anybody else about this case until there is a decision, okay?
Absolutely.
All right, well, have a good trip,
Thank you.
okay? All right?
Thank you.
Take care now. Mr. Poulan, do you need your
Would it be
itinerary
possible
thing
to
back?
get a note saying that I was here?
Oh, absolutely. We'll
you
have
can
that
throw it
for
away.
you. We'll have that for you. If you want to have a seat just out in the hallway for a
Okay.
second, we'll get that for you, all right?
Thank you.
Or he can sit in the jury room.
Can if you want. Perfect.
Probably more comfortable in the jury room. Why don't you do that? All right, we'll be in recess till 8:30 on Monday. I want to see the attorneys in the back.
Yes, Your Honor.
I gotta go see the judge.
They're cold. Go ahead, sir. Well, I'll write that one. So Monday morning, we'll...
I think we'll be back.
Oh, good. Have a safe trip. Congratulations to your daughter. Who's she graduating?
Where?
Oh, good for her. Okay. Nice meeting you. Hope you come back on Monday.
Thank you.
Yeah.
Now, do you still have more questions?
A few more. Just a couple areas.